Hey guys, it's Kathy. I hope you're doing well. So, I'm putting a video out of a case. It's a divorce case in Wisconsin with Judge Frost again. And nothing crazy happens during this hearing. So, it was a motion to compel. The the wife's lawyer put a motion to compel because the husband, didn't put forward his financial statements or anything like that. So they had a motion to compel. Nothing crazy happens in this one. However, um, I think we see hints that in future hearings it's going to get good. So for completeness, I'm going to put this up as a video, and then you don't have to watch this now. We don't know if it's going to get good. I think it's going to get really good. So I wanted to put this here so that we had it later. It's only like 20 minutes long. Um, and it's in June, I think, which is not that far away, believe it or not. I know that sounds crazy, but it's not that far away. So, here's Judge Frost. We love Judge Frost. Although his Wisconsin accent is lacking, very lacking.
Good morning, Attorney Kratzer. Are you able to see and hear me today?
Yes, thank you.
Attorney Severson, how about you?
Yes, Your Honor.
Great. Attorney Plowman, are you there? Well, we're waiting. There we go.
There, apparently I had to hit OK on the being aware that the meeting was being live streamed. So yes, I am here and I can hear you.
Great. Mr. Is it pronounced Risolvato?
Yeah, that's it. You got it.
Can you see and hear me okay?
I sure can.
And then Ms. Dirks, are you able to unmute?
Yes.
All right. And you can see and hear me okay?
Yes.
All right. Let me call case number 23 FA 1373, Jessica Dirks versus Eric Risolvato. For the appearances today, who do I have for the petitioner?
Attorney Brian Kautzer appears with his client, Jessica Dirks. Good morning.
Good morning. And for the respondent?
Attorney Risolvato appears via Zoom and Eric Risolvato appears via Zoom and Attorney Cale Plowman appears on his behalf also via Zoom.
Thank you. And then our guardian ad litem.
Good morning, Your Honor. Attorney James Severson appearing on behalf of the minor child. I am appearing via Zoom.
Thank you. I do have everyone by Zoom today. I've confirmed everyone can see and hear me, and I can see and hear each of you as well. We're also live streaming since we're doing this for you by Zoom today. We're here on a motion to compel discovery. Let me ask first, Attorney Severson, did you want to talk about anything beyond that, or do you want to observe? Or if you want, I'll let you go today.
Normally, I would not, and I am not involved in the discovery except when I looked at one of the questions being asked, I believe in the discovery, I believed it was somewhat relevant to both my purposes and FCS purposes. So I don't mind being excused if I could just say why it's important. But I'm also happy to sit in. I just want to make sure that question is answered. I think it's relevant for FCS.
Sure. Well, I'll leave it up to you. If you would rather participate, I'm fine with that. I just wanted to offer.
And I do want to raise a past due fee issue, or at least schedule something for that as well, pursuant to local rule. Since everyone's here, we don't have to address it today, but I'd like to set it for a status pursuant to 409.4. I have a bill that's hasn't been paid for some time, so I just want to make the parties aware of that.
Do we ever see any GALs get paid when they're supposed to? Have we ever seen a divorce or a child or custody or anything where the GAL just gets paid? It doesn't seem too much for them to ask. Just pay them.
Yeah, okay. Counsel, do you want to address that today, or do you want to schedule another time to come together?
I guess from my standpoint, if Attorney Rizzovato is owed some money, please tell us what it is, and I'll make sure my client gets paid.
And I think it's Mr. Kautzer's client has been fairly consistent with paying. There is not a large balance due. Mr. Rizzovato paid his initial retainer, I believe, and there's been no payments since January. And I'm sending out my April bills, and as we go through the FCS study and perhaps a trial being scheduled, I'm just concerned it's getting large. It's over $1,800 as of today. So it's more for Mr. Rizzovato.
All right, Attorney Plowman, did you want to address that today?
Sure. Part of the issues that we're addressing right now is mostly appropriate levels of income for child support and all of that. I mean, that's the discovery is about. My client, if he were to testify, would say that he's been hitting pretty hard financial times. That said, obviously, Attorney Severson deserves to get paid. So if there would potentially be a payment plan of some sort towards that Mr. Rizzovato could begin making payments towards, I think that that's something that could probably be accomplished without further issue, but maybe we schedule a status conference if that isn't happening. That would be my suggestion.
In Your Honor, if Mr. Rizzovato calls my office sometime next week, he doesn't have to do it today. We could just make some sort of arrangement. I'd be fine with that. And if we can't, I'll just let the court know by letter. If we can't figure it out, if this case goes through trial, we'll probably have to have another discussion given what can happen there. And I would like to be excused, but if I could just make my position on the motion to compel, I do think it's important to get an answer regarding the income issues, because one of the central issues in this case involves financial capacity to exercise placement, given the distance between the parties. I think it's very relevant. So I would like to get answers, and I think Ms. Schrodel at FCS would as well, because that seems to be a really big, I don't want to call it an excuse, but it's a reason the parties are giving for various things. So it's important, unfortunately, as it relates to the custody case.
And then
otherwise,
James,
save the parties time, more expenses for me sitting here.
And then James, we actually have all of that information together. We've just only been sending it directly to Attorney Kautzer. We can send a copy of that to you.
Okay, thank you.
All right, I appreciate the update. What I'm going to order at this point is I'm ordering each party, to the extent they have an outstanding balance due to the guardian ad litem or overdue, to be in touch with the guardian ad litem to make appropriate payment arrangements, as long as Attorney Severson is okay with it. If it's a payment plan, I'm fine with it as long as he's fine with it. And then if somebody doesn't reach out to you to set up an appropriate plan, or they don't follow through on it, just let me know and we'll put another status on. If and after we get our FCS report, I always do entertain what should the trial retainer be for a guardian ad litem. So we'll automatically talk about that when we have our status after the report comes in.
Thank you, Judge.
Yeah, thank you. I'll excuse you for today, and I hope you have a good weekend.
Thank you. Take care, everyone.
Thank you. So, turning to the motion to compel, Attorney Plowman, have you ever put a formal answer, a formal response to the request for production together?
All right, he's going to say words here, but the real answer is sorta, kinda, a little bit.
Yes. So to sort of give the timeline on this and to agree in part and disagree in part with Attorney Kautzer, I believe technically everything was late because there was initially discovery sent to Mr. Rizzovato before I was on the case. The all responsive documents were sent by March 15th, but there was not a formal answer at that time. There was another email that I believe Attorney Kautzer just slipped his mind on the 15th that included pay stubs as well. We have been in contact since then about supplementing that, and I have a proposed final supplement on this, which is basically, there was a period where there were not pay stubs, but there was other forms. It was a draw from an owned company, and we were proposing, we sent taxes, for example. We're going to be sending taxes on that. But I believe 4/23 is when the signed discovery response came in. So the one amendment to what Attorney Kautzer had to say is that there was the rest of the documents on March 15th, but I will concede that the actual formal signed response was a little over a month late from our agreed upon deadline.
And the signed response was provided by the end of April, you said?
April 23rd, Your Honor.
Okay. Attorney Kotzer, do you agree with that? Did you finally, by April 23rd, get that signed written response?
There was a written response provided by that date. So the information, I think, as Attorney Plummer kind of described, came in kind of piecemeal. The documentation came in piecemeal. And then a written response was provided on the 23rd. The problem is that there were some documentation, there were some things missing, which we then wrote back to Attorney Plowman saying we're missing pay stubs from January 1st of 23 to November 15th of 23, and then from pay stubs from February 3rd of this year to February 16. There has been some back and forth as to why that is, and apparently there's an explanation that there weren't pay stubs. And what I've asked that Mr. Rizzolvato do is provide an amended response to that to explain, because that was not part of the initial written response, that there were some holes in here. So that's what I'm asking be done at this point.
So a question on that, are you asking, you're saying there are no documents, you just want him to put in writing an explanation why there are none?
Correct. Yeah, so they provided responses and are now saying we don't, and I wrote back saying you didn't provide us with pay stubs from these different periods. And my understanding is the response is, well, I didn't have pay stubs during this period. And so my request, and I'm asking the court to order this, that he provide a written response detailing why there are no pay stubs for that period of time.
Part of the problem with that is it's a request for production. So the way you respond is you provide documents, and if they don't exist, they don't exist. So you've complied. If you wanted an explanation for any of the periods where there were none, that would require an interrogatory.
Sure, and I could do I could do an interrogatory on it.
I mean, I agree, like, efficiency wise, what you propose is what should happen. A lot of people in response to a request for production to say, here's what I have, these periods, there is nothing responsive. That's great, but I'm not going to order him to answer as if it's an interrogatory when it was a request for production with no related interrogatory saying for all the periods for which you don't provide any, explain why. Because that's not appropriate. I can order him on a motion to compel to produce documents when we're dealing with a request for production, or to put in writing an answer saying I've produced my documents. I can't order him to respond to an interrogatory that was never requested.
And before we get too deep into this, Your Honor, because I believe that Attorney Kotzer could very just easily ask an interrogatory, we have prepared a document that I believe is responsive to what he wants us to affirm. And we are trying to provide some supplementary documentation that isn't responsive to the discovery request. But for example, there's one paycheck that was done via, I forget if it was Cash App or Zelle, but it wasn't an actual pay stub. So we're trying to get documentation on that and the taxes for that year, which there weren't pay stubs for, in addition to a signed discovery response explaining why he's getting these alternative documentation rather than pay stubs going back to January, because I think that avoiding another round of discovery on this is in everyone's best interest. So that's our plan. I believe I sent out a draft of that document to everyone this morning.
Okay.
Your audio's fine. He's just thinking.
So I'm just thinking, and I was rereading 80409 to figure out the right thing to do here. Because it was reasonable for plaintiff to do follow-up, meaning once counsel was involved to say, hey, this hasn't been provided, it's due or overdue. Then to check in and say, hey, it still hasn't been provided, it's due, way overdue. And then to say, I still haven't received the written response because that you are entitled to that by statute. I was trying to review if my recollection was lawyers sign requests for production and it doesn't have to be under oath or anything like that. And that is what it says, is it's just a written response. It's not sworn under oath like an interrogatory. So I was trying to determine if I think there's any prejudice there. I don't know that we needed any of this after a written response was provided and signed, because what you're asking for is really for an interrogatory. Informally, the counsel and the parties, it would have been great if you had resolved that and gotten an explanation or done other discovery. But I'm not going to award any time after the written response was provided, because what you're asking for after that point is something beyond what your discovery request asked for. It would be unfair and inappropriate for me to compel discovery that was never issued or to award any fees for that. So, but I am going to find that there was reasons to file a motion to compel because it was filed before a written response was provided and signed. And up to that point, there was a basis for it. So I'm going to grant the motion to compel, oddly or ironically or whatever you want to put it. It's already resolved because it sounds like a written response was provided along with all responsive documents that exist. That's all that's required for a request to produce. I haven't heard anything about there being any objections or that you're trying to get me to overrule any objections. So I'm only going to award fees up to the April 16th, 2024 date. The fees for on April 23rd to review the response, that's normal, that you would incur if somebody had complied with it. So I'm not going to award that. And then as I explained, everything after that was asking for something beyond what I can award. So I'm not going to award any of those fees. I haven't totaled it up, but I'm going to do so right now.
And I'm assuming there's an affidavit with a billing statement somewhere.
I'm looking at it. Looks like it came in yesterday.
Okay. Oh, I had the view documents tab open from yesterday, so it didn't have that. Okay.
So I subtracted everything from 423 on from the total that was provided. And that gives me $892 that I'll award as reasonable and related to the motion to compel. So I'm granting the motion. The order would be to provide the written response with all documents. That's already happened, so I don't need to set a date for that. And I'm ordering fees of $892 for having to go through that process. I guess what I'll do is I'll set a deadline to pay them of divide it by 5 and pay 1/5 every month for the next 5 months. If it hasn't been paid off by then, we'll certainly address it in a final judgment. Whether we have to use property division or something else to pay it off, but it really should get paid off before then. So that's why I'm making the order for 1/5 every month starting June 1st, and then at the first of every month after that for 4 more months. Any questions about that, Attorney Kotzer?
No, if my math is correct, it comes to about $178. a month.
and 40
So,
cents.
I'll put
Yeah.
that in order.
Okay, 178.4 it looks like.
Yeah.
Any questions, Attorney Plowman?
That was only gonna be my clarification too, is the monthly amount. And
Okay,
my calculator agrees.
sure. So anything else either of you want to talk about? I mean, I'd strongly encourage you to try to do informal exchanges, save some money for everyone. And both parties should cooperate with your attorneys to do that promptly. If you have to do discovery, you have to do discovery, and that's why it's there.
Do
Anything
you-
else I can help with though?
Yeah, I just have a question. I'll do the order. Do you want me to include your prior order on the parties making contact with the guardian ad litem to arrange for payment arrangements?
I would appreciate that, sure, as long as you're
Okay.
drafting.
So, again, nothing crazy happened here. I just have a feeling that it's going to get good when they start talking. So, I wanted to put this in for completeness so we can come back and look at it. It's 20 minutes of our lives. So, all right, guys, I hope you have a great day, and I will talk to you next time. Bye.